Hey everybody, this is Uncle Grumpy and welcome to Grumpy Tonight. I want to introduce my guests. I've got Rachel Bussett-simco and Julie Ezell, lawyers that work in the Oklahoma City area, here to talk about cannabis. First, I want to thank the sponsors. This week we've got Green's Bakery in Oklahoma City, which is not only a dispensary, but she is now making the goodies for about 100 different dispensaries throughout the state, as well as Sweet Leaf, which is doing all three: grow, process, and dispensary in Bartlesville, and Max's Garage here in Muskogee. So I want to thank all our sponsors for helping us get this far. Okay, ladies, I want to thank you both for coming on. And would you like to introduce yourselves a little bit?
Sure. My name is Rachel Bussett-simco. I'm the attorney with the Bussett Legal Group in Oklahoma City, and we've got several lawsuits for 788. Most well-known is the suit that was filed down in Cleveland County that caused the Department of Health in Mike Hunter to redo their rules. We're also representing some folks out in the city of Yukon, as well as Dr. Evans down in Cleveland County challenging the physician rules, and we're helping businesses get rolled out in this area, as well as helping patients and how it impacts them across multiple areas of law, not just in 788.
Okay, and Julie, your name's come up quite a bit since the beginning of this. Yes, it has. So what are you doing in the industry right now, or are you doing anything in the industry?
Yeah, I am somewhat active in the industry. I, as everyone probably knows, was the general counsel of the health department until July of last year. I've worked in state government pretty much my entire career, and now I'm in private practice on my own. I do special needs, special education law, but also, staying plugged in and focused on the medical marijuana law and how that's evolved, just because it was so near and dear to my heart for so long.
Not only were you tied in due to your work at the health department, but you both come at this from either a patient or the parent of someone you would like to have a patient be, right? You have a child that has needs that might assist?
Yes, I have 4 children, and my oldest son has autism, and while he hasn't ever needed to take medical marijuana to this point, I do have a lot of friends whose children have benefited with it, either for their seizures or for behavioral outbursts and things like that.
Yeah. So, and I know you've said before online, you've stated that you yourself were a patient like myself.
Right. So I am a patient that has pain control issues. I have been on some sort of pain management for most about the last 10 years. And so cannabis was something that when it became legalized, I wanted to look into for myself, as well as I too have family people who need it. I have a 18-year-old daughter who has multiple autoimmune disorders that research indicates cannabis might help her improve that, as well as she has pain issues from years of being a competitive gymnast. Additionally, I have 2 nephews who both potentially benefit from medical cannabis, one of which was a named plaintiff in the Cleveland County lawsuit because he has seizures, and cannabis helps treat the seizures.
So what we have is all three of us don't just come at this from a business angle, but from a personal angle. And 788 meant something different to each one of us. So, and I want to acknowledge that most of the people involved in this, no matter what angle they work at, from the business angle, from the attorney angle, if you talk to us, you find out we're all connected to this one way or another. So, Rachel, you say you've been involved in some of the lawsuits. Recently, we have seen this new, what we're calling the Skinny bill roll out,
Okay.
which we know is a shrunken version of the Unity bill. Now, without taking on that whole elephant in one bite, are you surprised to see this roll out like this after the 6-month waiting period?
Yes and no. I always expected that the Unity bill would roll out differently than how we presented it. It was a lengthy bill, and that isn't typically the kind of legislation that Oklahoma would have come across, even doing major reform. I am disappointed that it went from 200 and some odd pages down to 93 pages because they took out some good portions, and I think there's some great portions of the Skinny bill, if that's what we're calling it. But I think they also left out a lot of things. So I would have liked to seen it be introduced and broken down in components addressing certain things. Like the focus of this one that we have in front of us now really seems to be licensing. And I think that's great. It would have been nice if we had one that was about licensing, if we had one about patient protections, and if we had one maybe about employment, or and even a fourth about lab testing standards, so that the legislature could attack it in small bites. But to go from 200 and some odd pages down to this, I think that they have left out a huge portion of the issues.
So you're surprised. You're not surprised it's come out, but you're surprised the way they put it out, or the shortness that's in there now.
Yes.
Julie, are you were involved in this at the beginning? Are you surprised that it's rolled out like this? And are you surprised that these different organizations like the OBNDD are trying to, in my opinion, backdoor change 788 with rules and regulations?
I'm not really surprised that the bill is coming out now. They had an opportunity for a special session and even legislation prior to 788, but being that it was an election year, they just weren't going to touch it. And so I think, this is a good starting point. Like Rachel said, I think that it misses a lot of areas and is too burdensome in others. But as for your, comment about, am I surprised that other agencies are trying to backdoor in or get more authority and power through this or through rulemaking? No, absolutely not. It's been my observation in a lot of state government that, a lot of people aren't necessarily for medical marijuana and want to restrict it as much as they possibly can. And I also think that generally, anytime, you're looking at agencies in state government, you have, what we call kingdom building. And so, this agency's always, had their foot in this basket, and they're not going to, give that up easily, whether it's, OB&DD, whether it's pharmacy. I mean, it just, nobody wants to
very
let go
territorial,
of
aren't they?
Absolutely.
Now, yeah, go
I was
ahead.
going to say, can I make a follow-up to that? In that, part of the issue that we have with 788 that we don't always have in other legislation, because 788 was activist written, 788 didn't fully develop out who had the authority to make the rules and what authority they had to make the rules.
Right. I'm hearing a lot of people saying the health department needs to be the authority figure, but the health department doesn't have the ability, and giving them, this is what I'm hearing from some, and then giving them a bigger budget to create a basically a law enforcement or somehow an enforcement agency to monitor this. When they have the OBNDD sitting right there, they can't seem to, that's what I'm being told behind the scenes, is they can't seem to overcome that. They don't want to leave it in control of the health department.
Correct. So you have the issue of, regardless of whether or not marijuana is legal for 788 purposes for medical use, it's still a controlled dangerous substance, and it's still regulated under the Controlled Dangerous Substances Act, and it's still illegal even at the state level under certain circumstances.
Now, that's what gives the OBNDD their power, right?
Correct, because they are able to regulate controlled dangerous substances. So part of the issue that we need corrected, and which I have not seen a lot of proposed legislation correcting yet, and I'll be the first to tell you I have not reviewed every piece of legislation that's gone before this year, but they need to correct how marijuana is defined in our controlled dangerous substances statutes, as well as outlining who has the authority to regulate it within the Department of Health and the other acts governing marijuana. And that will address which regulatory agencies really should be overseeing and doing some things. We don't want to have too much duplication between agencies, because that's not responsible state government. And we want to use the resources of others. But the problem that we have on a whole is we have so many areas where marijuana is impacted, and 788 just sort of plopped it down in this middle of an ocean of illegality and said, here's an island of legalness, and we have to figure out how that island works and what that sea is like around it. And that's really where all the problems are.
Yeah.
Legalness, is that a legal term?
That is a legal term. I'm going to use that in a brief.
I wanted to just jump on to something Rachel said real quick. In the new Unity bill, it does specifically state that there, retail license holders, so growers, processors, whomever, don't have to get an OB&DD license. So that's a good first step, but it still doesn't change what she talked about marijuana being a Schedule I substance. And so even with this change, it could be argued that OBNDD still has rulemaking authority, for the program, even though the bill specifically says you don't have to register with them.
Well, now Scott Fettgetter put forward a bill that does give the power to the OBNDD, if I'm not mistaken. That's in his bill.
I have seen so many different bills that I have, and one of which I've heard that OBNDD is coming back in it. I don't know if it's Fettgetter or somebody else's.
He's on there. Again, that's where I was explained. It was explained to me that there was no other way to have a policing of the. I mean, I didn't necessarily agree with it. I'm just telling you what I was told.
Oh, I think there's all kinds of ways to skin a cat where you can put people in charge of it without them going through licensing. It goes through the same thing about OBNDD's ability to make these emergency rules that went into effect around the 14th of January, and how do those impact things? Because part of what's wrong with 788, and I'm not being critical of the people who wrote it, and I can't tell you I would have written a better law, but part of the issue that we have is they didn't write it from the perspective of how lawyers think and how lawyers write when applying it. They use great plain language. It's easy to understand, but there are holes in it.
Yeah.
And so,
it gives us all something to do.
Right. And so
that's how we feed our families, right? Thank you for that. Keep writing these bills.
That's right.
But how, as we line all of that out, that's part of that issue. And that's that island of legal in the sea of illegality that we have going on that we need to figure out. It can be regulated from a law enforcement standpoint, whether it's by OMMA and the Department of Health or OBNDD or your regular police department. It can all be policed. It's not all of the other statutes can go away.
Now, we sat in the room with the Joint Committee and we heard John Eccles say, as far as the federal government goes in this particular case, we're just going to ignore them. So if the OBNDD gets their power because it's federally illegal, and we're going to ignore the federal government, then why are we allowing the OBNDD in here?
Yeah, OBNDD doesn't get all of their power from the federal government. We have a separate statute in Oklahoma that schedules medical marijuana and gives them, authority over this area. So, it really is a federal state issue. But as to the state side, by legislation, we could very easily, negate the OBNDD's part in this if we chose to do so. And maybe that's what they're attempting to do in the new Unity bill. They're just not getting there yet.
Right. The correct action would be to not put it here, but to go into the Controlled Dangerous Substances Act and amend how marijuana is addressed in the Controlled Dangerous Substances Act and how it's defined and where it falls in line there for that scheduling, not worry about the federal rules, but put it there. That's part of the problem that we have. My island analogy is we've got these 6 or 8 statutes that are created by 788 that says medical marijuana is legal. But then we have all of these other statutes that say it's not legal. And then we get into the statutory construction war about what is legal and what isn't legal. For example, the old joke about puff, puff, pass. Is that legal or is that not legal? Well, if it's medicine and you can't share your medicine,
that's a felony. Then
that's illegal because you're distributing under the criminal laws, which haven't been updated.
Right.
You can't gift it patient to patient. There's nothing in 788 that says patient 1 can give to patient 2, because if it's a medicine, you can't give your controlled medicine to somebody else.
Well, look, I'm noticing, and as you say, if it's a medicine, this comes up so often because so many times since this has passed, we have to ask ourselves, are we looking at this as medicine? Are we looking at it as alcohol? Are we looking at it as recreational? Are we looking at it as pharmaceutical? And depending on who you're talking to about how they want to organize the whole program, that's what we're talking about.
Right.
And only that. And we're not talking about any of that other stuff if that's how they want it. Right. And it seems to be a problem we're having. Like I say, the OBNDD seems to be trying to regulate it like alcohol in a lot of ways. And it's not. And
I would agree.
And it's not recreational. So Julie, something you know about is taxes. It's not recreational. Why are we even considering a tax beyond the 7%? We're going to take a break for a minute, and when we come back, we're going to talk to Julie about the taxes. All right, we'll be right back.
Thank you.
I'm a cannabis activist. I started doing this a little over a year ago. And when I started, one of the issues I had was I was afraid to get up and talk in front of people. And so I wanted to do voter registration drives. But I couldn't see myself sitting in front of a table and waiting for a bunch of people to come and talk to me. So I put out on Facebook that I would come to your house. And I rode my motorcycle around the state for months, registering people to vote, sitting on their couch and having coffee and talking to them about 788, some for it, some against it. One of the biggest things I've learned in this last year and a half of doing this is the citizens don't want to be on a list. And while that's a generic statement, and I understand it doesn't quite fit with what you're saying here, the chilling effect of this rule has already caused people to withdraw. I now go to patient recommendation rallies where doctors sign their medical cannabis recommendations. When I take pictures, people immediately make sure I'm not in the picture. I don't want my boss to see I'm here. I don't want my wife to see I'm here. Whatever the case may be, they don't want their information out there. I'm always real careful about that and never cross that line. But the point here is, if I told them, oh, well, you're getting this, so I'm going to have to put your picture out here, then they would turn around and walk away. These people would disengage, and the next movement, whatever it is, will be stopped. Now, maybe cannabis isn't a popular issue at your table today, but it may not be cannabis next time. It may be something that you support. The problem here isn't the popular speech, it's the unpopular speech. And those of us that say the things that are unpopular worry about the repercussions of our own government. And this would, in our minds, put that fear on us to the point that we would recoil and we would engage less in our government. So I would just ask that, in my opinion, this insanity stop. This doesn't need to happen. Not to mention this $500 limit is extremely low. It's lower than the other states. And I also see, while I know you guys don't all meet in the same room, I also see a connection between the suggestion put forward by Senator Allen that there be a $50,000 bond for a rally of more than 100 people at the Capitol. That costs $500 with a bondsman. So to now have, if this was to pass, to have a rally at the Capitol, you have to be a registered indirect lobbyist. That's it. Thank you.
Thank you. AJ,
Oh, here we go. Okay, we're back with Rachel Bussett and Julie Ezell. Julie, before we get to the tax issue, the guy on the other end here just played a video of me speaking at the ethics committee, and we'll get to that in a second, but I want to get back to the tax issue. What I'm seeing, as I said before we went to the break, is I feel like we are treating this as recreational in every way that they can reach, and then calling it medicine at the same time. And it's our lawmakers doing it. It's, in my opinion, the no crowd doing it. The people that didn't want this to begin with are willing to accept it if they get their payoff. Mm-hmm. You know a lot about taxes. You and I talked about this issue before the show today. What can you tell us about their right to even do this?
You want me to talk about taxes? I thought I was here to be Rachel's bodyguard. I'm sorry.
No, it's the tax issue.
Well, you are so much taller than me and bigger than me. I mean, you're going to take it down.
Bigger. So I worked at the Oklahoma Tax Commission for about 7 years during my career. And so kind of have a individualized knowledge of this issue. And interestingly, as we were going through the rule development process, there was never any discussion about a sales tax in addition to the 7% sales tax that is articulated in 788 being collected.
So how is it they're now getting away with this roughly 15% tax that they're charging in the dispensaries?
Well, so 788 says that there is a 7%, and it specifically calls it a sales tax on gross receipts of the sales of medical marijuana or medical marijuana products. There is a different exemption statute. Actually, there's two of them that, in my opinion, specifically exempt marijuana from an additional sales tax being collected. And, you know, there's an exemption that says that any prescription or medication that has been, authorized by a doctor is exempt from sales tax.
Okay, but it's not a prescription.
Well,
it's
that's
a
where
recommendation.
right. That's where we get into this. Is it, is it a pharmaceutical? Is it medical, or is it recreational? Well, this bill is all about medical marijuana. It talks about patients and doctors, and the language in the exemption statute, it says, exempt from sales tax is any drug, prescribed by a doctor. Well, I agree with you. We call it a recommendation, but, in practicality, it really is.
It's only a recommendation due to the fact that they can't write it as a prescription or lose their license.
Absolutely.
Due to the federal government issue.
Absolutely. Right. And so there's that exemption. There's another exemption in a separate part of the sales tax code that reads very similarly. And I think going into it, it was the position of the tax commission that, those are going to apply. But then, politics get involved, and, the thought that, we can collect more revenue. And, if because it doesn't specifically, because it's not specifically a prescription, we're going to exempt it from that statute. There's also another body of law that says that, when a statute specifically speaks to something, that, you can't then apply something else when a statute specifically speaks to it. 788 specifically calls it a sales tax.
So just because it says there can be no other tax, since it calls it a sales tax, that should stop it there? Is that what you're saying?
Yes, it should stop it there because it already calls it a sales tax. And yes, there is another statute that specifically talks about sales taxes and what is exempt and not exempt. But because 78 specifically calls it a sales tax, that's enough to override the sales tax code there. But even if you had to take it a step further and, you didn't apply that, there's still the two separate exemptions for, drugs for medicinal use that have been prescribed or authorized by a doctor. So I think either way you spin it, it still gets there. But, this was an opportunity, just based upon, a little bit of odd wording to add in, an additional sales tax, just like they did with the doctor recommendation. I mean, the doctor definition, it says Oklahoma board certified. Again, they're using that certification wording to limit it to doctors who are not only, licensed by medical licensure board or the osteopathic examiners board, but they have to have this national board certification because of the word certified. Well, that's not what was intended, but this was another way to, tie this program down and to, again, limit patient access to medical marijuana.
Okay, before we figure out the solution to the tax problem, you've been involved in a lot of helping create some of these businesses.
Correct.
What have the business owners seen as this tax problem that we're running into? What are they doing about it, and how did they come to that conclusion? Who told them what to do, and how much are they collecting at this point?
Sure. The numbers that I have seen are that there's a substantial amount of taxes being collected. I know as an individual lawyer, as I'm working with these retail dispensaries that are looking to open up, because retailers are really the only ones that have to worry about the sales tax issue. When they've asked me and I said, it's unclear as to what the intent is. I believe when I read the statutes that it is intended to be a 7% tax for marijuana and only a 7% tax for much the same reasons that Julie is.
So are you encouraging your clients to not charge a tax beyond that?
But in an abundance of caution, I believe that the way the Oklahoma Tax Commission is interpreting it is that sales tax have to be collected. So since you're tracking all of the data, I personally think the best policy is to charge sales tax now. And if it's determined at a later date that sales tax doesn't apply, then you can refund those or give a credit to those specific customers. And you're not in a position of having not withheld tax. So you get into a tax consequence with the state of Oklahoma because of federal illegality. Any kind of tax problems, I think, is inviting the government into your business to try to find other problems.
But the businesses are giving this money to the cities. They're paying these taxes monthly, right?
They should be, yes.
So how, even if they're keeping track, which we told them not to, okay, we don't want them tracking all of our information, but even if they are, how are they going to reimburse that? They gave it to the city. The city's not going to give it up. That's a wash.
That's when you've got things coming back to you. But you are in a position now where the law is in conflict. And how do we go forward? I believe, like Julie, that the sales tax wasn't intended to apply. 788 is a specific law, and it specifically addressed taxes.
Okay.
But I still think you are in a position where if you're not collecting sales tax, you as a business owner have become highly liable.
Okay. Now, I had heard that there might be something in one of these new plans addressing the tax issue. Julie, have you found anything in the Skinnity plan?
The Skinnity plan, I like that name.
You like that name? It wasn't mine. I wasn't mine. I don't want to give the person credit unless he tells me to. I don't want to, but it wasn't mine.
All of the Skinnity plan really says to the sales tax is it sets up a revolving fund and sends that 7% that is talked about in 788 to a fund that will, provide the money to run OMMA. It does not address, the essential double charging of sales tax. And, there's a lawsuit pending on the sales tax issue right now. The state's response to that is, even though 788 specifically calls it a sales tax, in the lawsuit's response, they're referring to it as an excise tax, even though it specifically says sales tax. And 788, it's just another way to try to, take these little nuances of words and, essentially doubled it.
Well, I had heard the tax commission had made that determination while they were not in session, while the lawmakers were not in session, that they had made that exact determination right there, that it was an excise tax and therefore the cities could charge us. That was their justification. That's what I've heard.
Well, and I can tell you up until I left the health department that there was no discussion, at all of charging this additional sales tax. And so, whenever that happened, I was not part of those conversations. But I think it's, just plain reading of the statute and, typical statutory construction that, 788 says 7%. It should just be 7%.
Okay. There's our nightly train. We get those all the time. I wonder if they can still hear.
Let's hope so.
Well, what do you think is going to happen with the tax issue? If there's not a specific bill stating yes they can or no they can't, are we just looking at lawsuits?
Yes, I think that it needs to be specifically addressed by the legislature in a bill. There is a lawsuit pending right now against the Oklahoma Tax Commission regarding this issue. I do not think it will be successful, not because I don't think that the goal of it is right, but in Oklahoma to challenge the validity of a tax, you have to go through an administrative hearing procedure before the Oklahoma Tax Commission before you can take it to state court. So that process is going to have to happen before it can be challenged in state court. Hopefully the legislature will see, the problems they've caused, especially I personally think about, people who are on disability of very fixed income and, they're essentially paying double tax on this medicine that, gives them quality of life. And, the additional 7% can be a real big deal breaker.
Yeah. And a lot of them are giving up pharmaceuticals that their insurance covered.
Right.
So,
and that those same pharmaceuticals, even if they paid out of pocket on, they would not be paying a sales tax on.
And what something she said triggered a thought that I had, because I have bad allergies. And so I frequently have my doctor will write a script for me for things that are otherwise over the counter, Sudafed, Allegra, that sort of thing. And it didn't occur to me until Julie was just talking about it, the fact that when he did that, that has made those not subject to tax. So those over-counter medications that I can go in and I can legally buy that I would otherwise pay tax on, when my doctor writes them, even if they're not covered under my insurance, I am getting at a tax reduction.
Well, we'll have to keep that in mind. That's it. We're never paying tax on Benadryl again. Thank you for that one.
Here to do what I can.
Well, and what Rachel's talking about is the same exemption that I mentioned to you. It's not just for, it is for pharmaceuticals, but that same thing. And so why would you not apply that same exemption to somebody who's had a doctor prescribe them medical marijuana, recommend? They're buying it at a licensed dispensary. It's the exact same fact pattern for medical use.
Because the same people who are making this decision are the ones that charge what's called a sin tax for alcohol.
Right.
It's just because we don't like it, we're charging you extra.
You're absolutely
That's
right.
That's it.
Right.
And that's what they're doing to cannabis.
Yeah.
Again, they keep trying to regulate this and now tax this as if it's recreational. but they don't want to give us recreational or full access. They don't want it to be that easy. And
Well,
some
Chris,
of these,
it's because they know better than you what's best for you.
well, yeah, I've noticed that with my time at the Capitol, but I think they're catching on. You know, I've heard some good things about some of the new lawmakers that are in there now too. I've heard that a lot of them
Absolutely.
don't have the time of day for the old games. So I'm hoping that people communicating with everybody down there is actually getting through this time.
I hope so too. I think that whether you're talking about Congress or here locally in Oklahoma, we have gotten a lot of new blood in there. And so we've had a lot of problems over the years, not simply limited to the cannabis issues, that gives these new folks that are coming in an opportunity to step up and change the way we've been doing things, whether it's teacher pay or medical access or civil rights, any of that. They have a whole new group of people that will hopefully be looking at things with fresh eyes and new ideas.
So if there's not a bill about the tax issue, then we're looking at just lawsuits with that. What are the businesses going to do until then? Are they going to just continue to collect the taxes and pay it to the city, and we'll all just call it a wash when they decide it's no longer a tax, but we can't get the money back?
Well, I don't think there's an issue of a wash. You can go sue to recover to have it all paid back and all that
So
good
we
stuff.
all have to go sue our cities for
Yes.
the taxes back on the cannabis we bought last month.
Correct. But you can possibly get the money back, and maybe even attorney's fees if we want to help feed more attorneys and litigation in the court system.
You know,
I'm not
I
advocating
just
for
want to
that,
get them out
but
of our lives from the beginning. I don't want to have to go back and get my money back. I don't
Yeah.
want to have to give
And
it up
I
originally.
think the real goal there is, you're right. In theory, they'd be entitled to refunds, but who keeps track? But the real, issue would be stopping it going forward.
Right.
That would be the huge
Right.
benefit.
That would be our goal. Yeah. So I've noticed a lot that's not in this plan. You had mentioned it before. Let's talk a little bit about the parental protections.
correct.
Tell us about that.
Okay, so
Well, let me tell everybody first. Sorry to interrupt.
that's
but,
okay.
for those that don't know it, you were in the room with us, helping us write the Unity Plan. Your name was on there too, so hold her accountable too. So go ahead.
Sure.
I catch a lot of heck for that,
Hey,
so I gotta share it.
I hear you. The portions that I specifically worked on were related to family law and custody proceedings, because outside of the cannabis area, that's a lot of what I do in challenging the government and governmental involvement in our private lives is through deprived and DHS proceedings. And so I worked really hard on drafting some language. And when we were working on the Unity Bill, one of the things that that we were already getting pressure for was to not make it too long.
Right.
So I
remember having the conversation with you and that becoming so short, it couldn't be any shorter.
Right. Like they gave me 5 lines and
Yeah.
so many words, and I had to make every word count. And so, I came up with the narrowest language I thought possible that would protect these families, because we're already see it happening in court where lawyers are trying to put in decrees that individuals can't use their medical cannabis when they have their children. And I said, it's a medical device. It's no
Right.
different than any other prescribed medical device.
Right.
If you have to use it to treat pain, if you're on an opioid when you have your child, you have the right to have your medical marijuana if that's what it's recommended for when you have your child.
They'd probably be okay with you stopping by and buying a bottle of wine on the way home, though, to take
Right.
care of your kids.
Right. And so, that's not an issue unless you can prove conclusively that you have a drinking problem. Up until this point, if you tested positive at all for marijuana, you clearly had a marijuana problem because
Right.
it was against the law. But it's not. It's medicine. So if it's medicine, and that's how we passed it, then it needs to be medicine across the board in every area that we regulate it, including family law. And unless there is evidence that it's being abused or misused, it should be treated like any other medication that an individual would take during their custody proceedings. And it's also not going to be the basis for a deprived proceeding unless you can show it's interfering with the ability to parent or is going to cause a risk to the health, safety, and welfare of the child.
So you and I think, have both spoke to John Eccles, the floor leader, in the last day or two about this.
Correct.
And are you confident that it's going to get back in there sufficiently? I know he's anxious to try and fix that part. Or I know you've passed on some language.
Right.
Are you confident that's going to get taken care of, or
I
do
am
we
not.
need to light his phones up and remind him? Maybe everybody needs to make a phone call. and remind him?
Sure. So the advocate side, or strike that. The lawyer side of me understands John's concerns about putting it in this particular piece of legislation because of the risk of overruling legislation if we put multiple subjects in there. And this is a controversial subject, and the anti-people might come in and try to overrule it based on violating the single subject rule. At the same time, we already have DHS protections in 788. So the language that I want can be accomplished by simply amending the statute that was created in response to 788 and adding that language. And that doesn't violate, in my opinion, the single subject rule, because you're already amending a statute where that is.
Okay.
The problem with the Unity Bill is the Unity Bill creates new statutes. It's not amending the statutes created by 788. And we have some issue there about also conflicting language that has to be resolved.
Okay. We're going to take another break, and when we return, let's talk about the single subject rule. All right, we'll be right back. Okay. All right, we're back with, sorry, a little silliness going on off camera. We are back with Rachel Bussett and Julie Ezell. Rachel, before we took the last break, we were talking about the issue with the single subject rule. Something that I must say, after my limited education, I didn't even know what that was until this last summer when we started working on that Unity plan and talking about a special session. And then the word single subject rule came up a lot. Can you tell us a little bit about what that is and why that's a problem here?
Okay, so basically the single subject rule is, and Julie can jump in if she feels like it because she's way more the administrative guru than me, but basically that a set of legislation can only really address one subject at a time. So if we are addressing public health and safety in this one, we shouldn't be adding in perhaps controlled dangerous substances would be a bad example. Education.
So one subject.
Yeah, it should be on
per bill.
One subject per bill. And so what that subject is really depends on how you're defining it. If you look at the subject of this bill, the Skinnedy bill, is medical marijuana and how medical marijuana is regulated under our titles, our statutes, I think you have wide variety of the subjects of which you can touch on. Licensing, physicians, family, etc.
So single subject just depends on how far you back off to spread your umbrella?
Correct. I believe that's true. And, you know, we've got all kinds of issues in both the original passage of 788 as well as in the Unity Bill. I understand Representative Eccles' concerns because if we get into multiple subjects, that allows somebody to come in and challenge and turn over the entirety of the legislation, the entirety of this particular bill and packet. And we don't want to see that happen. So that's what he has expressed to me. His concern is about this DHS language.
You know, it just came to me that I can put this in terms that a grower might understand. It's like having your light canopy. If you put the light close enough, you get a smaller canopy, but you get much better product. If you back your light up, you cover a much bigger canopy, but your product isn't nearly as good. If we back this up and try and cover too much with these bills, we make too many mistakes. There's too many chances for this overturn you're talking about of the whole thing because there's too many things that could be wrong.
Right, which was why when I heard the initial plan was to put it in chunks, I thought that was a great idea because you are limiting the ability.
That's what I heard too. And there is, look, some of these other bills do have things that go along with this. We do have to take some of those into consideration. Now, that would mean they have to go through as well.
Correct.
And, you know, that's a hit or miss. So,
but part of the problem is that we have is the Skinnedy bill actually introduces new sections in Title 63 that don't currently exist with regard to making modifications. For example, this addresses patient protections. It doesn't go in and modify or amend 620, which was created by State Question 788. It creates a new numbered statute. So now we have the old language in 420 plus potentially this new language in a new section which conflicts with one another. So the mechanism by the way that they're going at this and not addressing the other specific statutes that have already been created by 788 creates a problem as well.
So how many subjects do you think this is actually this Skinnity bill? How many do you think it is?
You know, I really think it's only one. We are talking about medical marijuana. Is there a big reach with medical marijuana? Yes, you have, processors, you have growers, you have safety issues, you have licensing. There's so much, but it all ties back to medical marijuana. And, viewed through that lens, it is a single subject. And, I think the courts on cases that have challenged this, have been pretty lenient on that definition of single subject. And this one, I think, fits that challenge, and adding in the language that Rachel discussed, again, it relates back to medical marijuana, should be perfectly fine to add in.
And it's already related to an existing statute, which is 425 that was created by 788. So if we're going to amend those statutes that were already created by creating new sections, which the Skinnity bill does, there's no reason we can't have our DHS language here, or that we can't have it in an amendment to section 425. Do I think we need to go amend Title 10A and 43 as it relates to children and families? Absolutely. But I also think we need the specific bill that's in the legislation that specifically relates to medical marijuana, because this is a specific subject.
Okay. So Wednesday, we're going to take up this specific subject in this joint committee. I know they call it the bicameral committee, but they'll have to get over that. The joint committee on Wednesday, will either one of you ladies be there?
I will not be able to be in attendance. I will be in court on another case.
Okay, well, you have taken this one apart pretty well. Can you give me some highlights on how we need to be approaching this for Wednesday?
Yeah, sure. I'll just to summarize, there are some really good things in this bill. It cleans up the doctor definition. It doesn't require them to be board certified, just licensed by the Medical Licensure Board or the Osteopathic Examiners Board. It takes out the requirement to register with OB and DD. And it seems to have pretty good, reasonable standards.
It takes out the requirement to register with the OB and DD.
Yes.
Okay, so then we have to get a look at Scott Fedgetter's bill, because that's what gives the power back to the OB and DD.
Yeah, and that's the interesting thing about legislation is you have all these different bills go in different ways, and which one's going to win and which one's not. But this one, as it stands, takes away the requirement to register with the OB and DD, and they still, OB and DD would likely still have some rulemaking authority because medical marijuana or marijuana is still a scheduled substance, but it would definitely shrink their authority in this area. And like I said, there's some good language in here on testing and packaging. The two areas that give me the most concern personally are regards to patients and business owners. As to patients, there's a provision in there that the Department of Health can contact any physician who has written a recommendation to a patient for medical marijuana recommendation and verify the need for the license. So they can get on the phone and say, hey, you've diagnosed Julie with anxiety. Is that still the case? Does she really still need it?
And the doctor has to justify that to the person on the other side of the phone.
And we don't do that with other medications. Nobody calls up to ask if my daughter really needs insulin.
No, no one ever questions. No one calls my doctor to ask if I still need my pain medicine.
Right. And there's also a provision in here that the doctor, if he determines that a patient who he's already made a recommendation for no longer needs the recommendation, he can notify the Department of Health and they will revoke or suspend the patient's license.
Now, and that doesn't specifically say it has to be the doctor who wrote the recommendation, does it?
It says a doctor, you're right.
Right. So if you go into an emergency room because you need a surgery, that doctor can refuse to do your surgery until your card is canceled. Right. So you turn over your card, they destroy it, call and cancel it.
In theory, I would think that doctor would have a medical malpractice claim on their hand for failing to treat you. But yes, a doctor who did not write your recommendation, in theory, could call the Department of Health and say, Chris no longer needs his card. Take it away. That
can't happen. That has to stop.
Absolutely. They shouldn't have additional physicians having the opportunity to second guess. I understand that sometimes we might have a reason to come off, but you should be specifically working with a doctor, some other doctor randomly treating.
It's things like this. It's finding things like this in bills that makes me have trouble trusting the legislators that we're dealing with. Because I meet with these people. I like these people. Most of them are very nice people. But you see stuff like this and you have to scratch your head and ask why.
Well, by and large, I don't think most of them go into it with nefarious purpose. There are clearly some people who...
But not to interrupt you, I'm sorry, but then somebody please explain to me, what would be the reason for needing that? Is there any one reason where that would be justified?
What I would be speculating, but my guess would be they would argue their intent was if you had a doctor who was treating you and wanted you to come off of it for a specific reason, or it was your prescribing doctor, that would be it, rather than thinking through about how the words they wrote down actually read and
so
could
you
apply.
think it was just a misinterpretation in the language, and that they would have liked it more to be that your own doctor had that control?
I would
not
hope
just,
so.
But the language comes out.
Yeah, the way the language reads is that it could be any doctor, and I could see, we all get prescriptions for medicine, and at some point maybe we don't need that medicine anymore, and so the doctor just stops prescribing it. So I can understand there would be a circumstance that perhaps a doctor who made the recommendation would think that their patient no longer needs the recommendation, and I can understand that, but that is not the way it's written.
Right.
And, a couple other things in this bill that give me pause, especially related to small business owners, is, anybody wanting a business license is going to have to show a lot of information to the health department, regarding their assets, their capital, their sources of funding, the amounts of funding and assets. And, the reason that was stated in the bill for that is due to federal restrictions on lending and banking. I would take the position that those restrictions are between the business owner and the institution that might be lending them money. And there's no reason for the health department to have that information. They don't set minimums. They don't say anything they can do on it. So it really just kind of seems like they're searching to gather information.
It's just an information gathering.
Exactly. Again, when you're doing other businesses, you're not doing that. You're not providing all of these financials, and there's not a number in there that it says you have to prove that you have so much money in this kind of asset or that kind of asset.
So it's not a means test.
It's not a means test. It's just, hey, we want to look at everything you own and everything you got and how you're doing this. And on one side, I get it. They don't want black market cartel money, but on the other side, if it's a legal business and it's just like other legal businesses, we need to treat it the same way we treat all other legal businesses. And it's none of the government's damn business what assets I have or how I have access to them.
Right. And the problem I see is what we want a lot of people who have been doing the cannabis industry illegally for most of our lives in Oklahoma to come out of the shadows and to bring their money with them.
Right.
And so we don't want them to have to answer these questions to get in the door. We want them to be able to just come in and do business. So that's why I don't like it.
Yeah. Right.
But I understand the need to keep the cartel out. There's got to be a line somewhere in between the two.
And I've seen, other provisions in here that I think, like you said, are going against black market activities and the cartel and stuff like that. But the unintended consequences of these provisions are going to be that they're going to impact, patients and business owners. This bill gives the Department of Health a lot of enforcement powers. They will have, commissioned officers doing investigations, who have, the power to, suspend licenses and have, enforcement powers. They can, with 24 hours notice, they have to be allowed to come inspect any commercial premises. They've also got, provisions in there for seed to sale, which I understand, again, they're wanting to stop the black market cannabis, but this bill requires small business owners to use a seed to sale software system. The financial impact of that on a small business owner alone, could be insurmountable.
Yeah, the price went up on a seed to sell system the minute they added that language.
Right. And this along with the enforcement powers, and this was a really odd provision to me, and I don't understand why it's here. Anytime they're proposing to revoke or suspend or take any other negative action, not only on a business owner's license, but on a patient license, it says that these are open hearings, open to the public. Anytime you have, in front of any other state agency, if you're a doctor having your license for suspension or anything else, those are confidential proceedings, not open to the public.
Even a review of a personal patient license,
if it's being revoked or suspended, that's my reading of it,
would become public.
The hearing, the hearing of it. So the
whys and the hows,
right?
And the
if I'm presenting evidence at a hearing, related to my medical condition, or if I own a dispensary,
your security protocols, your banking protocols,
then all that becomes public information.
Yes.
Now, but this does come to us from the wonderful department that put out everybody's address on the internet, right? You guys remember that?
I did
Oh,
not
yes.
work there when that happened.
We know that. We know
I was
that.
challenging them.
Were you?
I still am.
Good.
you know-
Someone needs to.
Just a couple other things in this bill to make people aware of. It requires anyone who works for a commercial medical marijuana entity to have a business license to work there, and it costs $50.
Right.
This bill gives rulemaking authority to the Oklahoma Tax Commission, Banking Commission, State Treasurer's Office to, write rules that implement some of this, but it does not give it to OB&DD, interestingly. So I really do think they're trying to get OB&DD out of this business, but they haven't quite got there yet. The other thing that gives me pause on this one is that if you are a renter, you have a patient license and you're renting a home, you have to get the permission of the person you're renting the home from in order to do your home grow. We're not making meth here, people. We're growing plants.
Right.
And to have to get the, landlord's permission there's really no purpose to that. I don't see what, growing a plant, what the negative impact
violates your constitutional rights to privacy under the Oklahoma Constitution.
Okay, then that's how we need to fight it. Because I see an issue with safety. In other words, if I'm renting somebody an old house with old wiring, and I don't know they're getting ready to stick a 1,000-watt light in that bedroom, that might be a problem.
Well, you as a landlord have a duty to make sure that all your wiring is up to code and
Well,
is
certainly.
proper. And so if you've got a 200
reality.
Right. But I mean, if you're in a really old house, you should probably have your wiring updated
Okay,
anyway.
so we're going to have people putting in grows without permission, and then when the house catches on fire, the landlord's going to be held liable.
Well, no, the landlord's not going to be held liable. The grower or the tenant is probably liable as well. That's why they should have insurance, but that's a whole other argument.
Well, then we need to stress that. Get renter's insurance.
Yeah.
Maybe we need anybody who's growing their own needs to take it upon themselves to make sure they have renter's insurance.
Yeah, I mean, I think common sense in a lot of these things, if you live in an old house, like you said, maybe I better, check into this wiring before I plug a huge lamp in. But, what Rachel said is that's really a privacy issue. And for the government to require your landlord's permission to govern the activities that you do in your own house behind closed doors it's a big step.
I love to hear it when people say stuff like that, because you spend too much time at the Capitol and you start to think it's okay.
No.
They reach this far, and so we think if we only let them get this far in invading our personal freedoms and our own rights, that somehow we're okay. But they've still managed to get that far into intruding in a place they had no business.
Right. And the government should regulate on things that involve the general public health, safety, and welfare. That's part of its goal. But there is a line, and that line is somewhere here. And what we do behind closed doors between consenting adults, et cetera, and that means, in my mind, sex, religion, medical, et cetera. That's the government doesn't need to belong in there beyond the general health, safety, and welfare. Right. They shouldn't be telling us who we can marry. If the medication is legal, we have the legal right to do it. If we have the legal right to worship, then we can worship, whatever the subject may be. And, we are a conservative state, but and conservative is supposed to be on the idea of limited government. So it really surprises me sometimes how much this conservative government moves over into our privacy rights where it's a sin tax or a sin issue.
Yeah, our own Senator McCourtney, the co-chair on the committee, has put out a bill that takes personal freedoms back and gives more control to the doctor in multiple ways.
Well, and I think that same bill that you're referring to is also the one that, changes the criminal penalty. 788, currently says that if someone's pulled over, doesn't have a medical card, and has
$400 ticket. Yeah.
Right. Well, so his bill changes it to where it's only if you are not a medical marijuana license holder, you're going to get the same criminal penalties.
Yeah. If you can't prove you had the license at the time that you were pulled over and just didn't have it on you, then it'll be $1,000 fine and a year in prison. That same bill also
allows counties and cities to ban growers and processors, because 788, I think through a drafting error says that cities, municipalities, counties, can't make more restrictive ordinances as to, is it medical marijuana dispensaries? Retailers, but it doesn't mention growers or processors. And so he's using that under statute, allow them to completely ban growers and processors.
And additionally, what 788 does say, though, is 788 says that cities and municipalities and counties can give more rights to patients in particular, but
Right.
more rights, not less rights. So
I got to ask, have we heard of that happening anywhere yet?
giving more rights?
Yes, because I keep hearing about how cities want the home growers to register, which just sends me into a tizzy.
Right.
So, but have you heard of anybody getting, I mean, my city's yet to call me and say, hey, Chris, you know what? We know you're growing the legal limit, but we want you to double that. I'd love them to do that. I'd love them to do that.
You're waiting for that call.
I'm waiting for that call. Yes. Clipping clones as soon as they make that call. That's it. No,
I haven't heard that. I've heard about that in other states. I do know of lawyers that are working for cities that have contacted me and talked to me about it, and they confirmed, okay, as I read this, it says cities can give the patient and the individuals more rights, not less rights. Is that your interpretation of it? And I said, absolutely. They don't have to make it a $400 penalty. They can make it a $200 penalty. They can say that you can grow 50 plants or whatever within the city limits.
So maybe that will be the more rights that they give us, will be the less fines if we do make a mistake versus calling us and saying we can double our plant count. I just don't see that happening, other than in certain cases, and I would encourage this with cancer patients who need a lot, that will need to grow more, to contact their city, and let's see what happens. I want to hear how that turns out.
Oh, I would love to see it. And I don't consider having to register and pay a license fee to be the granting of more rights by a city. I consider that to be less rights.
Yeah, that is, in my mind, that's where we've gotten lucky and where we're having problems. Where we've gotten lucky is since the beginning, everybody has pretty much stayed away from the home grow, which has really always had me scared.
Really?
Because I always figure there's a big hammer coming somewhere. But again, nobody touches the home grow. But then
it's
the
because
cities.
Of you, Chris. Remember that initial meeting I had with you? You scared me.
I don't know about all that. I do remember that meeting, but I don't know about that. I do remember arguing over fence.
Yes.
I remember explaining how you were going to make me build a fence that matched the curvature of the earth so I could get the full day sun effect.
I was only doing that just because it was you.
Okay.
That wasn't for anyone else.
Well,
I need to hear the story on the way home.
It was hilarious. It was fun. It was fun. We had a good meeting. I think her and I spoke more during that meeting than anybody else in the room. So, but again, the home grow has been fairly safe, except for these cities and their attacks on the home grow. So it seems like it's not coming from the capital. It's just coming in small bites. And as far as like the one that I did deal with in Coweta, where they tried to get you to pay for the first class postage to notify every property within 300 feet of your property that you were going to be growing. That's the exact same policy they have for sex offenders.
That's crazy.
Tells you how they perceive that.
Yes. And I explained to the officer that he was now, and there was a bunch of people that lived there that had asked me to come up there. He was now personally responsible for their safety because they were going to put out all their information to their neighbors, telling them when they were growing. And the minute their lawnmower came up missing, I was going to show up there with a team of attorneys and sue them. And he took my card, and they wouldn't answer the phone the next day. I got 2 calls from one of the news channels saying they wouldn't answer the phone. And then the day after that, I got a picture from a number I did not know of their new ordinance, minus that part.
Oh, surprise.
But they still wanted the registration, the home registration. So,
and you know, I think maybe what these legislators and cities are forgetting is there are provisions in these rules, like you and I discussed about. You know, the grow cannot be, viewable from the street. It has to be, behind a fence and, lock and key and secured. And so it's not like people are growing this on their porch.
Yeah.
I don't know, other than the devil's lettuce, what the fear is, other than they just perceive it as something negative and don't want it.
And in response to that, I did an interview, I think it was last Thursday when we had the bad weather, about the city of Jones and the ordinance that they passed requiring patients and caregivers to register. So between the time that I did the reporter talked to the mayor in Jones, got their side of the story, where basically said they felt like they could just do it because there wasn't anything that prohibited them from doing it. And she came and talked to me at approximately noon, and then by 1 or 2 when she was back out doing the film version on the Mayor of Jones, and they were backing off what they were saying already based upon what I said. No, there is exactly provisions in there that say they can't do that, where it says they can give more rights, not less rights. But interestingly, he first only backed off patients, and he said, we're still going to register caregivers because nobody should have the right to go door to door and sell stuff without checking in with us. And I thought, they really have no idea what it is to be a caregiver. A caregiver isn't going door to door selling themselves as a caregiver or selling their patients weed. They're just acting to help acquire and dispense the medication as it's been recommended.
It could be their mother.
That's going to be my new career, Rachel. I'm going to go door to door.
There you go.
We all talked about buying rent houses in the city of Jones so that we could open up our caregivers and go into a new line of business. I mean,
just throw them in the back. I've got 40 of them.
You know, I had someone call me that had some rental property, and they wanted me to put them in contact with a lawyer that could put in there all these things that the renter was going to have to do for them to set up their grow, because she wanted somebody to come in there and grow. And I just said, why don't you just go with this as a business opportunity instead of making the grower do all this before you rent to somebody? Convert one of your rooms. Do it right. Don't worry about all this extra. You coming in she wanted to come in every month to make sure everything was, no mold. No, it's like, no, you're not inspecting.
Like a peach of a landlord.
But she wants them to grow.
Right. I mean,
so and I said,
is in the right
build
place.
it right, but just build it yourself. So it's done right and it's safe, and then just get out of their business.
That's an excellent idea.
So
I love that idea.
I think, you say you talked about getting rent houses. For anyone thinking about rent houses or has rent houses, convert a room. Put that out there that you don't have to put that out on Craigslist so you don't get robbed, but you can reach out to a few people.
420 friendly.
There's so many of us out here that would love to find a place like that to rent. So
yeah.
So let's wrap it up here. What have you got coming after Wednesday? Since you're not going to be able to make it at Wednesday's meeting, what are you doing around in Oklahoma City now?
Obviously I've got my own private law practice, and I'm, continuing to stay plugged in on pending legislation and, checking it against the rules and, giving advice and stuff like that. And just, my heart is near and dear to this subject. And so just, making as many contacts and, talking to my senator, talking to my legislators, and just staying plugged in on the legislation. Well,
you've definitely been one of my inside voices at the health department from the beginning. So I hope you continue to come back on the show. You've definitely got some insight that nobody else here has. Rachel, what are you going to be doing? I know you're in this industry, so.
Right. So I'm in the industry in a variety of ways. Thursday, we have a court hearing on the case involving the city of Yukon and what we consider to be their municipal overreaches. I'm still involved with challenging the doctor issue until the legislator gets that straightened out, and I think their bill still has some problems. I have lots of clients who are getting up and going in the industry, so working in partnership with them to get their businesses up and going and staying, again, plugged in, talking to both my representatives as well as the individuals on the joint committee and anybody else really that I feel like is interested and willing to listen to me about my thoughts on it.
That's great. Do you know how many licenses we have now as far as commercial? Do you know what we're up to?
I have lost count.
I did see a story earlier today about a record number of patient licenses.
Oh, the numbers have just
were approved last week.
Yeah,
like 5,000 or something. Which
right.
I guess is double the most they've done in 1 week.
Yeah, and
that's what this story said. I don't know.
Yeah, well, and it showed a huge uptick in December, and then it's just continued to multiply essentially every week since then. I kind of thought that when you first were able to apply that there would be a huge influx, but it really just seems to be gathering momentum and just getting bigger and bigger.
Well, I can tell you from boots on the ground, a lot of people are still afraid to get it. A lot of them think they're in a better legal position not getting the card. They're worried about being on a list, which part of McCartney's bill does make this public. It does bring out your private information. So, that's a problem. So a lot of people that I've spoke to are just now, in fact, friends I have are just now getting to where they're thinking about getting it. And most of them are doing it now, not because they're convinced they're any safer, but because they are convinced that the legislator is going to do something to stop this whole thing or to make it more difficult.
And I do think you're right. I
Right.
do think that the vast majority of legislators' heart is in the right place. You know, they are balancing a lot of constituencies and have a lot of people whispering in their ears. But I do think generally most of them do want to do the right thing. We just need some tweaking, and we need people to contact their legislators, talk to them about the problems with the Skinny bill, and also about the good things too.
Yeah, there is a few things we could live with, maybe.
The name.
Right. There are some great things in there as far as straightening out the process for getting licensing, creating a full-on transporter's license, because that was left out of 788.
Now, I'm only okay with that as long as there is no way for that to end up mandatory.
That you
Because-
have a transporter's
Well,
license?
because what I think that is a way to a different business, a new business, which is fine. I have no problem with a transporter's business if someone
Like
wants
the
to
Uber
go.
Eats of marijuana.
Sure,
Mhm.
but I don't want that to become mandatory, because then
I
we
see
get
what
into
you're saying.
distributorships.
Right.
And then we get into that's where you have to
I
buy
don't
it.
see how, 788, provides for a transport license. This new bill, definitely fleshes that out, but I don't see how under the plain language of 788 they could make it mandatory.
Okay.
I mean, if they did, it would be a conflict in statutes, but 788 is pretty clear on it. I agree with you.
We better keep a close eye on that one. Okay, ladies, I want to go ahead and wrap it up. I want to thank you both very much for coming all the way to Muskogee for
Thank
doing
you.
this. Thank you, Rachel Bussett and Julie Ezell.
Thank you.
Thank you.
Okay, everybody, we're going to wrap it up here at Max's Garage. I want to thank this week's sponsors, the Greens Bakery in Oklahoma City, Sweet Leaf Dispensary in Bartlesville, Max's Garage here in downtown Muskogee. Thank you, everybody, for watching. We'll put this out live very shortly, and hopefully we'll get you guys back very soon.
Thank you. We'd love to come back.
Absolutely.
All right, folks, stay grumpy. I'll see you on the road.
Bye.